Welcome back, everyone. In this video, we are going to cover police powers and their legal authority. So let's begin kind of with the constitutional bedrock that governs all police authority, the Fourth Amendment. It was ratified in 1791 as a direct response to these kind of British general warrants and writs of assistance that allowed unlimited searches, right? So if you read the Fourth Amendment, it says, hey, actually, we are secure or protected from unreasonable searches and seizures. And you can't just issue warrants without probable cause. Okay? So, again, that big important date when it was ratified in 1791, and then we see kind of developments around it in 1961 with the Supreme Court case Mapp versus Ohio. This is crucial because it applied the exclusionary rule to state and local police. So it then kind of extended the exclusionary rule beyond just federal agents. It's also worth noting here that there is a reasonableness standard, right? So it says in there, you're protected against unreasonable searches. Well, what is an unreasonable search, right? Like the standard is reasonableness. So the amendment doesn't prohibit all searches, right? Just unreasonable ones. There's also this preference for the use of a warrant. So the language warrants, in the language of the Fourth Amendment, warrants must be supported by probable cause. So you need reasonableness to justify your search and probable cause to justify a warrant. And it should be, when you get a warrant, it should outline the kind of specific place or thing to be searched, or what you're trying to seize, or whom you're trying to arrest. So this kind of constitutional framework creates a hierarchy of police-citizen encounters, which brings us to our next slide. So think of this kind of like a ladder of escalation where each level requires more justification and gives police more authority. So at the most basic level, you can have consensual contact with the police, where any reasonable person would feel free to leave at any point in time, right? This would be stopping to ask for directions, right? You can be like, yeah, I don't feel like talking to you anymore, and you walk away, and there's no repercussions for that. There's no reason to believe that you are engaged in anything illegal, so like you are therefore not in any type of custody. You've not been stopped. Like, it is just as casual as you perhaps approaching an officer at a job fair, right, and talking to them. That is consensual contact. At this point in time, if you are the officer engaged in consensual contact with somebody, you don't need to read them any Miranda warnings or anything, right? Because the person is free to go at any point, and typically these are contacts that are not going to implicate people in a crime. While usually in consensual contact kind of situations, it's rather like amicable, I suppose, between the officer and the citizen, or the community member. It's still important for the officer to, maintain situational awareness for their own safety and the safety of all those around them, right? Like, just still being aware of things that are happening in the periphery to be safe. As we move on up the kind of ladder here, we get to like Terry stops or stop and frisk situations. So this is based on the Supreme Court case Terry versus Ohio. Basically what it says is, hey, actually, yes, officers can stop you and frisk you, which is not a search. A search is more involved, more grippy than a frisk, as long as they have articulable facts that lead them to have like reasonable suspicion, or that they can articulate their reason for being suspicious of you based on specific observations, right? Not just hunches. It's not just this person's aura or vibes were off and I decided to stop them and frisk them. Stop and frisks must be brief, like minutes. The courts are increasingly more strict about how long these can go on for before you're kind of infringing on people's rights and getting into the territory of, well, technically, if they were detained for that long, are they under arrest and all of that kind of stuff. So brief, right? You have frisk authority as the officer only if you have some sort of reasonable fear for your safety and you are only frisking for weapons. Like, you're not looking for other evidence, you're not like digging deep. It is essentially a pat down to make sure that you and whoever else is with you, and even the person you're speaking to, remains safe during this encounter. Then we move on from reasonable suspicion. So that's if that is like kind of the bare minimum to make more questioning style contact, like questioning in the way of, I think you maybe are involved in criminal behavior. We have that to make some contact in perhaps a frisk. Then if we move up to probable cause, that is a higher standard of like proof, or a higher standard of suspiciousness. So at this point, you have a more than 50% likelihood that a crime has occurred. Okay, so this is all based on the totality of the circumstances. So you're considering all of the facts, including officer training and experience. At this point, when you have probable cause to believe that a crime has occurred, you also then have the authority to make an arrest, or it is justified once you have probable cause. You cannot arrest someone based on reasonable suspicion alone. There has to be probable cause to believe that a crime has occurred. Okay? At a formal arrest, this kind of custody triggers your Miranda warning, right? So if you're planning on asking the person any questions, you need to read to them their Miranda warnings. At this point in time, the officer may also conduct a search incident to the arrest or after the person is placed under arrest. This type of search is like, think of a pat down, but like far more touching, like you're taking the person's shoes off, you're like gripping their whole leg and going up and checking the insides of their pockets, right? You're searching their whole person. It's limited to, you should be still looking for weapons and evidence that could potentially be destroyed, right? So let's go ahead and examine these standards a little more closely, but particularly focus on probable cause. So this chart shows the certainty levels required for different police actions. So if you make certainty that like something has happened, right? If I make contact with somebody, I don't really need to believe that they're involved in anything nefarious to just chat them up, okay? To engage in a Terry stop, I should have reasonable suspicion, right? To believe that, like, given where they were, how they were behaving, I believe they have maybe done something and I would like to engage in a little chit chat with them to see if that leads to anything. And if it doesn't lead to something quickly, they're off the hook and I have to let them go because I don't have probable cause, potentially. Once I step up to probable cause, right, I need over 50% kind of certainty that this person has committed a crime. And that difference between the Terry stop, like reasonable suspicion, and probable cause is like in that gray area between those two is where we see a lot of legal challenges occur. Now, moving on down the line, you have like beyond reasonable doubt, which is what it takes to get a criminal conviction. You need to convince a jury, the evidence needs to be, the standard of the evidence is incredibly high, right? And the certainty needs to ideally be like 100% that this person did in fact do this crime. A preponderance of the evidence is in reference to getting a like civil suit settlement and what it takes to be like the winner in that kind of situation. So when we look at our probable cause, it's based on a kind of objective standard of what would convince a reasonable officer that something has occurred here. So examples of strong probable cause include witness identification, right? So somebody said, I saw that man punch that grandma right in her gut and took her purse and ran away, and he's right there, and I can positively identify him. Officer observation of the crime, so the officer watched all of that happen, right? Obviously, they have the probable cause there to believe that a crime has occurred. Or if they observe like physical evidence, so like drugs or weapons within plain view. So if the officer pulls someone over and they stop and in the passenger seat is several bricks of cocaine, I, as the officer, would then be like, it would seem as though this person is engaged in perhaps some drug trafficking of some sort. I can see it in my plain view, right? I cannot at this point confirm that they are trafficking drugs, but I have probable cause to believe they are, right? So at that point, I could potentially make an arrest. Or if the suspect just like lets you know that they did the crime. So they say, yeah, okay, it was me, right? Weak probable cause examples would be an anonymous tip without corroboration. So if somebody just calls in and says, it was so-and-so, it was Mr. Mustard in the library or the study with a candlestick, and then they don't identify themselves and they also don't provide any other like verifiable information to lead us to believe that it was in fact Mr. Mustard, then you have some problems, right? That's not really reliable and not enough to be probable cause or meet that standard, which then wouldn't allow you to get a warrant or make an arrest. General descriptions matching several people. So if I'm like, yes, it was a man wearing a sweatshirt and pants, that's probably going to be a lot of men, depending on what time of the year it is, right? So that's not going to be enough to have probable cause, or simply seeing someone in an area that is like known for high crime. That's not enough either, right? Just existing in those spaces does not give you, the officer, probable cause to believe that that person in particular is engaged in any criminal behavior. So when we kind of back up a little bit to our reasonable suspicion and those elements, so that is based on like officers' expertise, and that can kind of elevate innocent facts to suspicion. We have kind of the context that is going to matter a lot, right? the more that you see and the more that you know about a place, or maybe you've had several encounters with somebody or someone's family, like as you become older and you know more things in your department, perhaps you are able to articulate reasonable suspicion where someone who hasn't been with the department or hasn't had that experience could not. Behavior patterns, so like nervousness alone is not enough to say, yeah, I had reasonable suspicion and therefore could kind of stop them and talk to them and frisk them. But if they're being real weird and sketchy and nervous, and also there are other factors at the same time, like they're being all weird and they just walked out of some like house that you know of as like a drug house, well then that becomes potentially suspicious, right? But if they're just walking by anxiously, that's not enough. So kind of a critical point here, like these are legal minimums, so good policing often means having more justification than what is legally required. So think back then to our Fourth Amendment, right? It generally requires warrants for searches, but over time, we realize that there may be some instances in which there needs to be an exception to that, in which we just might not have time to get a warrant, or maybe you saw enough that you can articulate. A warrant requires probable cause, right? And so does you being able to make an arrest without a warrant. Like, the standard is the same, and there are situations in which you maybe just cannot get a warrant, and we have those exceptions. Starting with our like kind of searches that are incident to arrest. So this is a search that occurs after the person has been arrested. So we have searches are to be limited to be within the kind of wingspan rule, which is the immediate control area only. Like, I can't arrest you on your front porch and then go search your whole house without a warrant. Like, if I get a warrant to search your whole house, that's a different story, but I can't make an arrest without a search warrant and then proceed to search, all the spaces around you that you can't get to or not in your wingspan. When you are arrested, like from your vehicle searches are limited after the Arizona versus Gantt decision. So they can't arrest you and then search your entire car immediately without a warrant, unless they have like articulable, like plain view kind of evidence or something like that, another reason driving it. But like if they have no other reason to search your car, they can't just do that. Cell phones or other digital devices do require a separate warrant after someone has been arrested. So just because you're under arrest does not give the police authority to go through your electronic devices. So we have those are kind of like incident to arrest situations in which we don't need a warrant all of the time to do a search if the person is already under arrest, but that still has limits on it, right? Then we have exigent circumstances. So anything that might require police's immediate action. So normally I'm not just going to, as the officer, bust into a building or someone's home, like a private area. However, with the hot pursuit exception, If a suspect is fleeing into that building, I can then follow them into said building or like home, residence. Okay, so in that situation, I don't need a warrant to enter because I am actively fleeing or I am actively pursuing someone who is fleeing. If I am afraid that they are about to flush a bunch of stuff down the toilet or burn a bunch of evidence, I can enter a space without a warrant to be in that space to stop that from happening. Or if I believe that someone inside of a place needs like immediate medical attention, you can enter without a warrant in those situations, right? Really, what it boils down to is, would a reasonable officer need to act immediately? If the answer is yes, they can proceed without a warrant to do the thing that they needed to do immediately. There's also the plain view doctrine or exception. So anything that's immediately observable can be seized, can lead to like a area, like a within the area search, like a so like in your vehicle, right? Like if I observe the brick of cocaine, like I'm going to be able to search your car then, right? I will also be able to seize said evidence, but if it's within view of the officer and the officer didn't do anything, didn't move anything around to see it, and they have a reason to be in the space that they are in where they observed it, a lawful reason, all of those things, as long as those three requirements are met, then they can conduct a search or seize whatever evidence. Then we have consent searches, right? So this has to be a voluntary, yes, you can come in and search my home. It cannot be coerced. There can't be use of threats or deception to get that consent. It must be given by the person that has like actual authority over the premises. So like one of my friends who stopped by for lunch can't just say, yeah, come on in, right? Like they have no authority over the space of my home in that way. The scope of the search is limited then by the person giving the consent, and they can revoke or withdraw their consent at any time. So I can say, yeah, you can search, but you can only search downstairs. Or, yeah, you can search, and then I'm like, actually, this is taking too long, and I have somewhere to be, so I need you to leave, right? Like, all of those things are okay if it is just a consent search. And because they don't have a warrant, and you consented, and you decide to actually please leave, they do have to respect that, right? Some prohibited practices with searching. So we have pretext stops. So this is any time that you're trying to, if you're masking your illegitimate motives. So you're allowed to stop someone, but you can't like lie to them about why you're stopping them, why you're engaging with them, right? You're not trying to be, you as the officer shouldn't be acting suspicious, right? And then we have our prolonged detentions. So we have this court case, Rodriguez versus United States, which ultimately they decided that you can't extend traffic stops without reasonable suspicion. So if I make a traffic stop and I'm, like, hey man, why is your your taillights out or like you were speeding, whatever. But I don't have any suspicion to believe that you're engaged in any other criminal activity that would like justify me keeping you there. Then I cannot keep you there, right? Like, if you start acting really weird and there are some other circumstances that would make me have reasonable suspicion, then I could make you stay around and maybe answer some more questions, right? But I have to have that suspicion first. So also just back to the pretext stops. What they are is whenever a like officer pulls someone over for a minor traffic infraction, so like rolling through a stop sign or not using a blinker or going 2 miles per hour over the speed limit, right? Like any little tiny thing, they pull them over for that, right? But the real purpose is because they want to investigate a different, more serious crime. But most of the time, these things are based on hunches and not by any actual evidence. Like they have a hunch that this person did something criminal, and they want to be able to figure it out, but they don't have any other reason to engage with the person besides, oh, well, you didn't use your blinker that time, so I can now pull you over, right? So, according to case precedent, they can still do pretext stops, but it's not ideal, not a good look, right? So, at the federal level, like officially, by that case precedent, they can happen. Most state laws are stricter, so they might say, yeah, no, we don't allow that. And that's the case for many things. So, like, many states provide greater protections than the federal constitution requires. So, it is important to know your state's laws wherever you end up living. So then we get ourselves into use of force standards. So Graham versus Connor can establish that force needs to be reasonable based on the severity of the crime, immediate threat to the officer or others, and whether the suspect was actively resisting or attempting to evade arrest. And the reasonableness standard considers the perspective of a reasonable officer at the scene under rapidly evolving circumstances. So this kind of objective reasonableness should not be based on 2020 hindsight. So like you can't looking back be like, yeah, I would have done this differently, obviously, and it's like, well, yeah, but you weren't there and you weren't the one responding to a call with this particular like information that you were given from the dispatcher and like all whatever factors there are, right? Like sure, it's easy after the fact to say, well, I wouldn't have done that. Great. But when we're talking about like using force and whether or not it's justifiable, it should be evaluated based on the officer's perspective at the moment of the use of force incident, right? Like, it can't be, oh, well, you should have thought about this, and you should have done this, and you, like, okay, well, I didn't, or I didn't have that information at the time, and now I do, but, yeah. So, the three big factors, again, are the severity of the crime, so if it's a felony versus a misdemeanor, that matters. The immediate threat, so if there are threats to the officer, others, or public safety in general, that matters, right? Like, if it's a misdemeanor and there's no immediate threat, and the person also isn't really resisting or fighting, like, you probably shouldn't be putting hands on that person at all, right? So that then as the third one is our active resistance or fighting, right? So if they're not fighting and they're generally compliant, again, if it's a low level, nobody's in harm's way, and they're not fighting you, you have no reason to go hands-on at that point, right? So some kind of key legal points. These types of situations are rapidly evolving, right? Like these are split second decisions that are getting this kind of judicial recognition over time. We know that there is not always a perfect solution, so courts oftentimes recognize that officers don't have the luxury of time when they're deciding whether or not the use of force that was, like the level of force that was used was acceptable, right? They take those types of things into account. The totality test, so all kind of circumstances considered are considered together. So it's not just what they did, it's what all occurred leading up to it. It's the information that they were given or not given about a particular situation that led to a use of force incident. Like all of that matters when determining if somebody should be held like legally accountable for, or criminally or civilly really accountable for whatever the use of force outcome was, whether it was just say, hey, I thought this was excessive, I didn't like that he pushed me or like pulled me to the ground, cuffed me, whatever it was, like that. It can be that low level of force or up to, you know, like lethal force or deadly force. So determining, like anytime force is used, it's getting reviewed, and all of these things are being considered. So the DOJ kind of issued policy updates in 2020. So when force is used, they say it must be used out of necessity. In other words, there must be no reasonably effective alternative. There's nothing else you can do. This is your last kind of option. It should be proportional to whatever is happening. So you should be using the minimum force necessary to get control or get compliance in the situation. When it's feasible and safe, you should be trying to engage in de-escalation as an officer. And officers must stop excessive force by colleagues if they witness it. So if their partner or like co-responder, whoever it is, if they start engaging in force that is unnecessary or not proportional to whatever type of resistance the subject was using, then the secondary or the observing officer has a duty to intervene. They have to step in and be like, you need to go, you are doing too much, you are causing harm, you have to leave, right? Or you need to remove yourself from the situation right now. And then finally, they have a duty to render medical aid immediately after all force incidents. So if you've ever had, I would call it the misfortune, because I don't particularly enjoy watching like body cam or dash cam footage. There's one that they show at the academy where like the officers show up to a domestic disturbance. The subject pulls a gun on them, starts firing on them. They end up returning fire. The guy is shot, and like as soon as he hits the ground, they like one of them gets security of the kind of situation, and the other is over there like applying pressure, putting on tourniquet, calling for like medical assistance and backup, like within a moment, like as soon as the threat is neutralized, for lack of better terms, they switch to, okay, well now I have to save this person's life. Like that is my responsibility here. So we have that. We have some training implications with the updates from the DOJ. So they are encouraging using scenario-based training that mirrors the legal standards. There should be documentation, so there should be thorough reports always done after all of use of force incidents, because those are going to work to promote legally compliant officers or protect them, right? I guess these aren't part of the DOJ update. I'm sorry. These are just other things to consider. So yeah, the training, like you should be training to what you might encounter, and you should also be training to whatever legal standards that you are expected to uphold. You should be documenting everything. And then any supervisors should be immediately reviewing all force incidents. Okay. So we have our kind of Miranda warnings and interrogation requirements. So our Fifth Amendment protection is our right against self-incrimination, and a custodial interrogation, both elements must be present to be considered a custodial interrogation. So you must feel like you are not free to leave, like you are in custody, and also that like you are being interrogated. So at this point in time, if those two things are met, it is the responsibility of the officer to issue a Miranda warning, where they will inform the person of their 4 rights, starting with their right to, you have the right to remain silent, and then any statements that you make can be used against you. You have the right to an attorney, and if you do not have the means to, afford an attorney, one will be provided to you. Okay, so all of those should be relayed to the suspect in understandable language, and if they have language barriers, it should be interpreted, or they should bring in an interpreter to relay that information to the person, right? So we have that those requirements and what those are. So custody plus interrogation. What does it mean to be in custody? And really it is, would a reasonable person feel free to leave? If the answer is no, then you're probably in police custody. You don't necessarily have to be handcuffed to be in custody or under arrest to be in custody, right? Like at the point in which you feel like you can't just walk away, then it would be argued you should at that point believe you're probably in custody and shut up. Get your attorney. So then interrogation is direct questioning or words or actions reasonably likely to elicit any type of incriminating response. So some common misconceptions: traffic stops, typically you're not in custody unless it's a prolonged traffic stop. And then when you're answering any booking questions, if you are arrested and you're going to jail, when you are booked, those are just administrative and not interrogative. So those things typically are not going to be used against you for any type of criminal cases. Some best practices are to record any conversations or questioning with people. It protects both the officer and the suspect. Again, document things. So write down exact words especially if they waive their Miranda rights or their right to an attorney, their right to not speak. Like, if they waive that, that all needs to be documented. Know what it means for them to invoke their rights. So, like, I want a lawyer versus maybe I should talk to a lawyer have different legal effects. Okay? So, like, I want a lawyer is I'm not talking to you. You should stop asking me questions. And maybe, like, you could argue that that wasn't clearly them saying, hey, I don't want to talk to you anymore until I have an attorney. So if ever in the situation, I would recommend zip it. Zip it until somebody with a JD shows up. Somebody who practices criminal law shows up. You don't have, if you are in custody, you don't have to say anything. You shouldn't. Please don't. In fact, like, and I know that if you watch true crime or listen to true crime, people are like, oh, like, they lawyered up real fast. And it's like, yeah, that is the very smart thing to do, in fact. So there's that kind of, like, oh, that looks suspicious. Who cares? You have the right to it. You should take advantage of that. And then, if the suspect does invoke their rights, the investigator has to stop immediately. You can't then continue to, like, probe and see if they'll answer something. Like, once they say, yeah, get me my lawyer, they have to stop questioning you until the person is there. Okay. So finally, kind of some legal developments and trends. So it's different court decisions and policy changes really continue to refine boundaries of police authority and emphasize our constitutional protections while maintaining effective law enforcement practices. And they're able to do this by making sure that people are getting trained on these things and, being compliant with these practices. So we have one of the legal areas, use of force, particularly focusing on enhanced de-escalation requirements. So following high-profile incidents, courts are increasingly scrutinizing whether officers attempted de-escalation before using force. The 2024 DOJ guidance emphasizes that de-escalation must be considered whenever feasible and safe, right? So we have this kind of key legal shift. So some jurisdictions now require documentation of de-escalation attempts in use of force reports. Our practical impact here, officers should be trained to verbally communicate, create distance, and use time to their advantage and request backup when possible. And they should be ideally engaging in scenario-based training that emphasizes communication skills and tactical patience. For our kind of digital evidence area, cell phone search restrictions in particular. So Riley versus California in 2014 established warrant requirements for cell phone searches, but 2024 cases are narrowing exceptions further. So recent court decisions limiting search incident to arrest for digital devices. Those have kind of come down the pipeline. So some courts now require separate probable cause for different data types on phones. You could argue that there are some exigent circumstances potentially, like those, like, oh no, what if they get rid of this, right? But it must be truly immediate and evidence destruction alone may not justify a warrantless search of someone's cell phone. So a best practice is to always seek warrants unless you have some genuine emergency that exists, and document exigent circumstances thoroughly. Regarding vehicle stops, we have extended detention limitations coming down kind of as a development. So in Rodriguez versus United States in 2015, they set this kind of foundation, but 2024, as of 2024, cases are defining reasonable duration more strictly. So courts are increasingly critical of traffic stops and extend significantly beyond ticket writing time. If you somehow get a drug dog alert, that must occur within normal traffic stop timeline or time frame unless additional reasonable suspicion develops. So you can't just pull someone over, be writing them a ticket, and also call the drug team to come like sniff their car without any other reasonable suspicion. So this all makes documentation incredibly critical, right? Officers should note specific reasons if they are extending detention and extending that traffic stop and the timeline of those events. So this also kind of creates an emphasis for training, particularly that which is efficient, trying to let them know, hey, you should be efficiently processing traffic stops. And if you aren't, you need to be clearly articulating any additional suspicion factors. As we kind of move through time and space, we see like body cameras being implemented at several departments. With that comes recording policies and standardization. So the DOJ encourages standardized policies across departments around like what they're recording, when, how, to kind of maximize consistency. So really those big questions or big areas that have to be addressed are: when are you supposed to activate your body camera? What are the notification requirements? How long is that data supposed to be retained? And what are the public access protocols around that footage, right? So courts increasingly expect body camera footage when it's available. So it's evidence. So that kind of can impact all of those things that we just mentioned around like when can it be released and who can have access to it and all of that kind of stuff. If you are recording stuff on your body camera and you know that this case might not see a court date until 3 years in the future, like, is it then a requirement to store all body camera footage for at least as long as the longest criminal trial could take, or what? Those are all things that they have to figure out. There's also this need to balance transparency with privacy rights in sensitive locations. So do you turn it off when you enter a hospital, a school, or somebody's home? Because there are expectations of privacy in those spaces, right? Or you're interacting with potentially vulnerable populations. Do you leave it on the entire time? What is the expectation there? Those are all things that have to be ironed out. And then finally, the kind of crisis intervention protocols addressing mental health issues. So there's a growing recognition that traditional policing approaches may escalate mental health crises. Departments are facing increased litigation for inadequate responses to mental health emergencies. And so there's this push for across states to mandate crisis intervention training for their officers. And this involves kind of like a really big coordinated response, right? We have this emphasis on partnering with mental health professionals during these types of calls, or at least having people who are sworn who have really specialized training and who are very skilled in that type of work and those types of calls. This also brings to light some use of force consideration. So courts are kind of applying heightened scrutiny to force that's used against individuals with mental health crises. So all of those things are important in terms of like how we should be training for them, applying training to those topics, and ensuring that departments are compliant with those expectations. Okay, that is all that I have for you for this video. I apologize it was so long. There's a lot of content to cover. All of this will be available for you to review like in the actual slides on Canvas. So if you feel like I missed something or whatever, like it will all be available. So don't worry about that. All right, until next time, I won't see you. You will hear me then.